Susan Jordan, the Director of the California Coastal Protection Network, and I'm here today to talk to you, I know you can't discuss it in public, but about the recent ruling this week in the Gaviota Coastal Trail Alliance Challenge to the Hollister Ranch State Coastal Conservancy and Coastal Commission Settlement Agreement. A little recap sorry for the spacing here, it was fine when I uploaded it, but a little recap for the newer commissioners. In 1982, the California Coastal Commission offered to dedicate public access as part of a permit for the YMCA camp, which was adjacent at that time to Hollister and later was bought by Hollister. In 2013, the Coastal Conservancy accepted that OTD before it expired, and the Hollister Ranch Homeowners Association and several individuals sued both you and the Coastal Conservancy. In 2017, the Coastal Conservancy and the commissions agreed to a settlement which abandoned the ODD and its easements. No public hearings were held before that decision was made, and no notice was given to the public. In 2018, as the settlement was moving towards finalization, the court ordered that the notice of the settlement be given to the public, and before she affirmed it, and offered the public an opportunity to file for intervention in July. The settlement was, for our perspective, quite egregious. It quitclaimed the public access OTD. It restricted public access to the beach that was in the OTD to the ocean only. There were no restrooms or facilities if you survived the trip there. Created a restrictive chaperone managed public access plan that was controlled by Hollister Ranch, and it was to be paid for with public funds, including the in lieu fees that were required by the legislature in 1982 to pay for the approved 1982 Hollister Ranch Public Access Program. That's contained in the Coastal Act. It's clearly laid out, and those sections were recently amended by AB 1680 by Assemblymember Monique Limon. That subdivision plan was approved. It was never implemented. There's an ad hoc alliance of 4 small NGOs, myself included, and we were granted the right to intervene by the court and to challenge the fairness of the settlement. We have argued to the court that the settlement is unfair to the public for numerous reasons: exclusionary of the general public, chaperoned access for small groups only selected by Hollister, the use of these public in lieu fees and other public funds to pay for their private managed access program, and because it did not follow the proper procedures for the disposition of state property, the OTD, which requires that the public be notified and allowed to participate in public hearings prior to approval of any transfer of state property. The court found that the OTD and the easements were state property. The settlement was a transfer of state property and subject to certain procedures prior to disposition. The state failed to retain a permanent property interest as required by law. It did not provide for undiminished public access as required by law. And the Coastal Conservancy did not provide public notice or hold public hearings as required by law under 30609.5. The settlement is now invalid and unenforceable based on the court's ruling. And it states that, based on the court's determination with respect to noncompliance, there is no present valid agreement. Our request as the Alliance is that we believe the court correctly recognized the importance of public access at Hollister. If you have not read the ruling, it's a very clear, concise, logical ruling. I don't think it leaves any wiggle room here. And even though the court did not rule directly against the commission, and when you read the ruling, you'll understand why, the rationale about notifying the public and including the public applies to it. We believe that the commission should now that it's invalid and unenforceable, we believe that the commission should work with the Conservancy both to defend the OTD, not to quitclaim it, not to give it away, and to pursue meaningful public access at Hollister Ranch through the state-mandated public process. We all know that the 1982 general plan is being updated. That is separate. That was a requirement of the Coastal Act. This was a lawsuit brought by Hollister against you and the Coastal Conservancy, and really trying to actually, in a very kind of subtle way, by taking the in lieu fees that go to fund the 1982 update, they were trying to kill both programs. They were trying to kill the OTD. They were trying to kill the 1982 plan. The 1982 plan is proceeding. We would like to be on the same side as the Coastal Conservancy and the Coastal Commission, fighting to defend the OTD. And so that's my ask, is that our ask is that this settlement is very problematic, it's no longer valid, and it should not be revived. Thank you very much, and I have extra copies of my presentation if anyone wants one. Thank you.
Thank you very much, Ms. Jordan.
Oops.
Frank Angel? Oh, I'm sorry. Frank Angel? Morning, welcome.
Good morning, Mr. Chair, dear Commissioner.